In 1999, Jason Strong, 35, was tried, convicted, and sentenced to 46 years in jail for murder. The prosecutor in the case, Michael Mermel, argued that Jason had savagely beaten an unidentified woman to death. However, Mermel's star witness in the case told so many versions of what happened, Mermel was forced to admit the witness was, truthfully, challenged, yet insisted to the jury that he could still be trusted. What the prosecutor intentionally withheld from the jury was that the victim was married to a violent schizophrenic who admitted to the murder. When Jason's attorneys discovered this information 6 years later, they demanded the case be reopened. But to this day, Mermel has refused to reopen the investigation, arguing, taxpayers pay for convictions, not intellectual curiosities. While we can all agree that Mermel's disregard for the truth is outrageous, it's also frighteningly common. And as a result, too many innocent people fall victim to prosecutorial misconduct, or the practice of government attorneys of willfully disregarding the law with one goal in mind: to win, no matter what the cost. A 2011 NCIP investigation of 4,000 cases ranging from 1997 to 2009 revealed that in 707 cases, more than one case a week during that time period, prosecutors are found to have engaged in explicit misconduct, with 62 of those cases resulting in death penalty sentences for defendants who were later exonerated. Jason Strong never imagined that he would spend almost 10 years behind bars for a crime the prosecutor knew he didn't commit. Nor did the 62 men and women who were sentenced to death based on prosecutorial misconduct. But while Lady Justice may be blind, we can no longer pretend this isn't happening. So it's critical we uncover the problems of prosecutorial misconduct, expose the reasons these problems persist before we finally insist that our justice system is held to a higher and proper standard. While we must acknowledge that the vast majority of prosecutors do behave in an ethical manner, those that do engage in egregious misconduct are wrongfully imprisoning the innocent. On April 23, 2011, the USA Today recounted the story of Nino Lyons, who was thrown behind bars by prosecutor Bruce Hinchelwood for alleged drug trafficking. The jury found Lyons guilty after hearing his fellow inmates, all of whom testified in exchange for reduced sentences, alleged that Nino had sold them cocaine. What the prosecutor intentionally withheld from the jury was that their star witness in the case, who claimed to have bought hundreds of pounds of cocaine from Lyons, couldn't even properly identify his picture. On December 29, 2011, the New York Times detailed the case of Michael Morton, who, after being wrongfully convicted of murdering his wife and spending 25 years in jail in Texas, was exonerated on DNA evidence. The prosecutor in the original trial, Ken Anderson, not only withheld exculpatory police reports from the lead investigator, which proved another man committed the murder, despite a direct order from the trial court to produce the full reports, he also attempted to cover up his misconduct by advising his successors to deny all requests by Mr. Morton for DNA testing. Prosecutors have enormous power in determining who is subjected to criminal punishment because they have broad discretion in deciding criminal charges. The Brady Rule, established by the Supreme Court in 1963, is supposed to be an important check on that power, as it requires prosecutors to turn over evidence which is favorable to the defendant. The Times continues on January 2, 2012. It is the height of hypocrisy when prosecutors who call others to account for breaking the law break laws themselves. Michael Mermel, the prosecutor in Jason Strong's case, according to the June 20, 2011 Chicago Tribune, has since been found guilty of numerous other instances of misconduct leading to false convictions. Yet he's still prosecuting the citizens of Lake County, Illinois. And Ken Anderson was actually promoted to state judgeship. The question is, how are they, and so many others, able to continue? The answer is twofold. First, prosecutors are immune from civil recourse, and second, there are no real consequences for engaging in misconduct. The 1976 Supreme Court case of Imler v. Patchman created separate standards for prosecuting attorneys and every other attorney. According to this ruling, prosecutors cannot be sued, even for willfully disregarding a defendant's rights. The one small consolation is the courts did at least rule that prosecutors can face discipline, including potential disbarment. However, while theoretically prosecutors can be disciplined, in reality it's rare. The NCIP report laments that fewer than 1% of prosecutors have ever had their licenses suspended, even for brief periods as a result of proven misconduct. Not surprisingly, the lack of consequences means that there's no real disincentive not to engage in misconduct to win. On October 5, 2011, the Los Angeles Times reported that of the 707 cases detailed by the Innocence Project, 67 prosecutors were found to have engaged in misconduct multiple times. Los Angeles County Deputy District Attorney Grace Rye was singled out as a striking example of repeat prosecutorial misconduct that has never been disciplined. Appeals courts found that she had violated court orders in 2 separate murder cases, resulting in wrongful imprisonment, and engaged in numerous other instances of misconduct. Bruce Hinchelwood, the prosecutor in Nino Lyons' case, was actually disciplined. If you consider attending a one-day seminar on ethics enough discipline to make up for the years that Lyons spent behind bars for a crime Hinchelwood knew all along he didn't commit. Eventually, Hinchelwood was removed from the Lyons case, and Nino was exonerated. However, not all defendants are afforded the same opportunities. Lanny Brewer, head of the U.S. Justice Department's Criminal Division, said it best. Even one example of real prosecutorial misconduct is too many. If there's been misconduct, our response must be swift and strong. A response that must include immediate action from the U.S. Supreme Court, the American Bar Association, and from us as voters. The 1976 Supreme Court case of Imler v. Patchman created prosecutorial immunity, and this would seem to make a solution all but impossible. However, subsequent decisions have allowed for the narrowing of the scope of that immunity. In 1982, in Harlow v. Fitzgerald, the courts ruled that this immunity only applies if a prosecutor's behavior does not violate established statutory or constitutional rights that a reasonable person would have. Using this standard, it's critical that in all violations of the Brady Rule, such as in the cases of Michael Morton, Nino Lyons, and Jason Strong, prosecutors are subject to civil suits. And while civil suits are a good first step, Imler specifically allowed for disciplinary action to be taken in cases of misconduct. It's time the American Bar Association start punishing those prosecutors found guilty of misconduct, lest the name of all attorneys be tarnished by the actions of a few bad apples. This discipline can start at suspension, working all the way up to disbarment for the most egregious cases. This is no different than how any other attorney is treated for ethical violations. And just as with every other attorney, it's critical that this information be made part of the public record. The act of making discipline public also empowers us as voters to be a vital part of the solution. Fortunately, prosecutors work for district attorneys who are elected officials and are therefore subject to the electorate holding them accountable. The book, Harmful Error, Investigating America's Local Prosecutors, notes, in San Diego County, after several highly publicized instances of prosecutorial misconduct, the public became so aware of the problem that they successfully voted out the district attorney and demanded reform. Reforming our legal system is going to be an uphill battle, but like Lanny Brewer says, our response must be swift and strong. While Lady Justice may be blind, we can no longer turn a blind eye to prosecutorial misconduct, the reason these problems persist, or the simple, clear solutions to restoring justice to our legal system. Our Constitution guarantees everyone the right to a fair trial. But when those entrusted with the awesome power of the prosecutor's office are permitted to place their thumbs on the scales of justice, that constitutional guarantee of fairness is abandoned, and we're all at risk.